Jolly good. Well, welcome everybody. Welcome to those of you in the room, and welcome in particular to the people who are online. My name is Mark Thomas. I'm a past chairman of the branch, and I wasn't supposed to be chairing tonight's meeting. I was having some time off for good behaviour, but unfortunately the current chairman, James Richardson, who will probably come piling through that door in about 5 minutes, had a train cancelled on him earlier on, so I got a panicked text at about 5:15 saying sodding trains cancelled. But anyway, so before we get on to the main event this evening, just to mention we have one more meeting this year, and I haven't put up a flash introduction for that, but at the end of November, I think it's the 25th of November, I'll check it, but it's the 25th or the 26th of November, and you will all be notified. We have a mediation workshop where we have some practicing mediators who will be going through some nitty real questions and issues that they faced over the last few years. It'll be a panel of 4 very experienced mediators, one of whom was the chap who spoke to us in January about the likely introduction of mandatory ADR into the litigation system. Excellent speakers, and I'm looking forward to that. So that will be our last event of the year. However, tonight we're into construction adjudication, and it's my pleasure to have Jennifer Guthrie here. Now, I met Jennifer about a year ago. I've heard her speak, and also I have had undertakings from her organization, Pythagoras, when I'm sitting as an adjudicator, because obviously any sensible adjudicator isn't going to act unless they know they're going to get their fees paid. And so it's all to do with insolvency. Jennifer went to Cambridge, did a law degree at Cambridge, then became a practicing solicitor. She specialized in insolvency practice, and arising out of that, she was a founder and is now the head of business development at Pythagoras Capital. Pythagoras Capital have been going for about 10 years. I'm going to leave Jennifer to explain how they fit into the scenario and how they've been absolutely key to this development of construction law. So Jennifer.
Thank you, Mark.
The table is yours.
Thanks very much. Thank you and good evening, everybody, both in the room and online. I'll tell you a little bit about Pythagoras first. Some of you will have come across this, some of you won't. The best way of describing us is that before we came along, no one thought you could adjudicate on behalf of an insolvent company. When we started, everyone told us we were wrong. We definitely didn't know what we were talking about, and an insolvent company certainly couldn't run an adjudication. And sort of where we've specialized is that crossover between construction and insolvency, because construction lawyers don't like insolvency, and insolvency lawyers don't know construction. We sit nicely in the middle of that. As Mark said, we've been around for doing this for about 8 years now. Feels longer at times, but we definitely come at this very differently from, I guess, the established incumbents who were here before us. I'm going to run through. I've got a brief list up there of what we're going to run through tonight. I'm going to start with Bresco because everything starts with Bresco, and talk through the Supreme Court. I'm conscious that people have more and less knowledge of insolvency, so I'll talk through a few sort of key insolvency concepts. We'll revisit the thorny issue of whether or not there's utility in adjudication. You can probably guess my view. And I'll talk a little bit about some of the practicalities of adjudications on behalf of insolvent companies, the sorts of disputes we run, the issues that will come up. The final position ties into that, and then we'll run through a little bit of enforcement, which is the post-Bresco is the next battleground, where we will end up in the Supreme Court again at some stage. So it's a little dramatic calling it a collision, but it kind of is. It doesn't need to be. I know there are certain members of the judiciary and certain commentators out there that see an incompatibility between insolvency and construction. I actually don't think there is one. But this was this was where we really started. So we acted for the liquidator of Bresco, and we issued an adjudication. This was by no means the first adjudication we had run against on behalf of an insolvent company. People had threatened us with injunctions, but no one ever did Obviously, this is prior to Michael J Lonsdale's insolvency. This is a few years ago now. As I said, there was this inherent view in the construction industry that you couldn't / shouldn't be allowed to adjudicate as an insolvent company. As insolvency lawyers, you come at it completely differently. You come at it from the view of, well, actually, I have a right as a solvent company. It goes against all first principles of insolvency to have that right taken away from you just before you went bust. So we disagreed. We ran it. We had the injunction issued. Justice Fraser found against us in the first instance. Then we ended up in the Court of Appeal with Lord Justice Coulson and 2 family court judges. Unsurprisingly, sort of followed the existing views and found in favor of Michael J Lonsdale. And then we got to the Supreme Court. I've glossed over the bit on Rule 1425. I'll come back to that. Lord Briggs, the reference to Lehman there, Lord Briggs was involved in a lot of the litigation that came out of the Lehman bankruptcies. So he was very familiar with a lot of the insolvency law concepts, and he gave the leading judgment in the Supreme Court. And it was very clear that he was absolutely clear that an insolvent company does have the right to adjudicate, same as any solvent company. The Act says you have a right to refer a dispute to adjudication at any time. It doesn't say if you're a solvent company, you have a right. It just says you have a right to refer a dispute at any time. Lord Briggs was also very clear there is utility in adjudication. He made some helpful obiter, because we weren't talking about enforcement, but he made some helpful obiter comments about enforcement. But even leaving aside enforcement, he was very clear, well, there is utility in adjudication. And again, insolvency lawyer, you go back to first principles. Well, as an insolvency practitioner, you're trying to get in the assets of the company, you're trying to pursue claims, you're ultimately trying to realize money for creditors. Well, adjudication is a hugely helpful tool in exactly the same way as it is for solvent companies. I'm gonna skip over Stein and Blake, and I'm gonna come back to that when I talk about Rule 1425 on the next slide.
What's the implication of utility? You've used the term 3 times.
Yes, utility is a word that Lord Justice Coulson used. He thought there was a lack of utility in adjudication. That's why I put it in quote marks. I think there's a lot of utility in adjudication. And Lord Briggs was clearly of the view that there is utility in adjudication. It is an incredibly useful tool for any company, but particularly an insolvent company where you don't have a lot of insolvent construction companies go bust with no money in the pot. They go bust because they can't pay the guys on a Friday to get them to come back on Monday. So particularly in an insolvent context, having a low cost, relatively low cost, and no adverse cost procedure to be able to pursue disputes is hugely valuable. So a few sort of key concepts. I'm conscious that I probably have a mixed audience, especially online, of experience when it comes to all things insolvency. So I'm going to just introduce a few. And the first one's really important, actually. An insolvency practitioner is an officer of the court. So if you were to go to the insolvency court, they expect high standards from their IPs. You are an officer of the court, you have high standards. You are given a lot of powers and duties under the Insolvency Act. You're expected to exercise those appropriately, but you are expected to exercise those. You're expected to gather in the assets. You're expected to use your investigative powers to work out what's happened. Was there wrongdoing? Are there claims to be pursued? These are all things that you should do. And the insolvency court, which is where insolvency applications end up, is hugely supportive of insolvency practitioners because they know they have a job to do, and Parliament has seen fit to give them a very wide-ranging set of powers to do so. So that's a really important point to put in. Those powers and duties come from the Insolvency Act. And then you have the insolvency rules. So like many sets of legislation, you've got your primary legislation, and then it's supplemented by a bunch of rules. These were updated in 2016, but they are materially, for what I'm talking about here, materially the same as the previous ones, which have been talked about in case law for years. So Insolvency Rule 1425 is the one that you will hear bandied around. It is mandatory set-off. Now, it only applies in liquidations, which is people tend to overlook. You have Rule 1424 in administration, which is similar but different. Effectively, and people get all head up about 1425, it's just mandatory set-off. It just says, if you go bust and you owe £100 and you're owed £200 and they're the same people, you set them off. It's a net amount due of £100. It's very simple maths. But people, just going back to the previous slide, people get all confused about Stein and Blake. And Lord Hoffman gave a very, very reasoned judgment, and he was a super, super, super smart judge. But if he just reads one paragraph of Stein and Blake and takes it overly literally, he talks about the claims being extinguished. It's not that you've entered into a contract and it magically gets ripped up and disappear into the ether when you go bust. All it means is the amounts under that contract have to be set off against any other amounts owing between those two parties. It might be under that contract, might be under a different contract. But it is simple math at the end of the day. You add them all up and you work out the result. And this was a point that Lord Briggs made, again, talking about utility in the Supreme Court. He said, well, as an insolvency practitioner, you've got to work out what the position is. And there might be 3 contracts. Maybe you have an arbitration on one. Maybe you have a mediation on another, or you agree what that figure is. And then maybe you adjudicate on another. These are all useful tools. There's huge utility in each of those to be able to get to, at the end of the day, being able to say, right, I know what the position is on all of these contracts. Therefore, I can work out what the final net position is across everything. And the description as it's set off is mandatory and self-executing. It is in the sense that it happens as a matter of law, but there's then effectively an accounting exercise to be done. There is no real magic to it. It is just working out what's owed and applying some basic maths. And I feel that sometimes gets a little lost in some of the commentary. Anyway, just getting back to where I was. So admin and liquidation. Administration is meant to be about saving a business. So you would go into administration if there's something you might be able to trade, or at the very least there are some contracts or something else you can try and save all or part of the business. And there's a 3-tiered statutory purpose that the IP has to say, well, I can achieve this or this or this. And if they can't achieve the first, you go for the second. And the last one is getting a better result for creditors than it would if you went straight to liquidation. So there are tiers of administrations. Liquidation is the death knell of the company. You know, nothing's coming out of that. Nothing's coming other than some money to creditors, hopefully, at the end of the day. That's not to say that every business that goes into administration gets saved, but that is the purpose of it. It's meant to encourage a rescue culture. That was why admin was brought in the first case. CVAs, we see less and less of. Company voluntary arrangement is when you get creditors, a percentage of creditors, to agree to an arrangement. Now, normally the idea is that the company will trade, a certain amount of money will be used to pay off the debts, and it will keep going. Canon and Primus Build was a CVA case. Traditionally, the courts have been more lenient to enforcing adjudication decisions in favor of companies in CVA because they're looking at, okay, the business is continuing, so we should be more inclined to enforce there than we should if the business is dead, which is, in my view, not necessarily the right test to apply, but it has been. But we are seeing less CVAs. I know it's always, talking to IP clients, it's always hard to get HMRC to support CVA. So if they're a major creditor, you might struggle to get it through, but we are seeing less and less. It's much more company going to admin to either sell the business to an unconnected third party or back to the directors, or companies just going into liquidation. And we are seeing a lot of stress in the market at the minute. A lot of, even you look at the big names that have collapsed this year, there's a lot of construction companies been around for a lot of years that Michael J Lonsdale is a great example, that nobody thought would go, but have succumbed to the market. Okay. The market was saving utility. As I've said, as for a solvent company, it is absolutely a cost-effective route to resolve a dispute. We can refer a dispute at any time. It was interesting, the reason that Adam Constable refers to utility and Meadowside. So Meadowside was first instance, but Meadowside was after the Court of Appeal in Bresco. So before we got to the Supreme Court, Adam Constable was sitting there with a decision off the Court of Appeal that basically said, we don't think you should be allowed to adjudicate. And I like this quote because it makes quite clear that Adam Constable took a different view from the Court of Appeal. He said, adjudication is good for the overall administration of justice, and no doubt many cases which would otherwise end up in the TCC are resolved without burdening public resources as a result of the practical utility, my underlining, of adjudication, notwithstanding its temporary nature. Now, there is a question as to how many insolvent estates have the money to go to the TCC, but we have a very, very blocked court system as it is. There has surely got to be utility. And going back to your point about mandatory ADR, there's got to be utility in a process that does not clog up the court's time. It also, so many cases, I say this as a lawyer, just reward the lawyers. Lawyers run up huge amounts of fees. And how much utility is that when you can have a very useful process that resolves disputes in a much shorter time and stops the fundamental mismatch between a very powerful, very financially comfortable construction company against its far more impecunious subby. And if you take that from the solvent context, the same thing applies in insolvency as well. My final point in this point is that the same final net position, and Justice Waxman, so Balfour Beatty and Aztec was first instance. So most of these are our cases, by the way. I'll point out the ones that aren't, but most of them are ours. And Justice Waxman was the first judge I'd heard that really, in a construction setting, really applied that concept of mandatory set-off. And he said, it's just maths. I need to resolve this one and this one and this one, and then I just net them off, and that's my net balance. Which is refreshing, because as I say, a lot of times people seem to put some mystique into Rule 1425 that really isn't there. It really is just maths. So what is insolvent adjudication? We don't do smash and grabs. If you think about it, smash and grabs are all about cash flow, and they go against the whole final position concept. That's not to say that all we determine as final position. And when I say we, by the way, I have not checked. A couple of years ago, we issued the second most adjudications to RICS every year. I believe we would now be the first, but I have not checked. But we issue 3 or 4 a week. So we issue a huge volume of adjudications every year. I say 3 or 4, I'm probably underselling it, but I don't issue them. So here you go. So we don't do smash and grabs. Often it's the final position, but we refer lots of disputes. There are different ways of getting to the same result. So we might issue a discrete adjudication. Is there a repudiatory breach of contract? And I'll come on to talk about this, has a party breached the contract by not issuing an 8.7.4 statement, which I'll explain for those of you that don't try not to look at clause 8 of the JCT. I'll talk about in a minute. We might be getting a loss and expense claim determined. So there's all sorts of disputes that are absolutely useful, have a utility, that can be determined on behalf of insolvent companies. And if you've had adjudications from us, you will have seen probably all of these. Jurisdiction arguments have changed. So obviously a few years ago, they were all about lack of utility, we should go for an injunction, there's no jurisdiction. Pretty much everyone's given up on that now. We occasionally get a couple of half-hearted enforcement arguments. They're pretty half-hearted, because that obviously doesn't go to jurisdiction, whether it's enforceable. Because of insolvency issues, has nothing to do with jurisdiction. And then just the normal stuff, no crystallized dispute, the usual kind of fairly lame, fairly half-hearted jurisdiction arguments that you get on any solvent adjudication. As Mark alluded to, guarantee of fees, the most important thing. Yeah, and I think many of the adjudicators out there know us now. They know how we work. They know that we'll ask us for a guarantee of their fees. We will give that. We wouldn't be in business, frankly, if we didn't pay adjudicators. So we do. There are other people around issuing adjudications on behalf of insolvent companies, obviously, but we do a lot. I've put on there the impact of the administration moratorium. This one is not entirely clear-cut, but it's worth covering. So when a company goes into administration, there is a moratorium imposed by law that says all proceedings that either were on foot or were contemplated at the time of the administration are effectively stayed. So you cannot litigate against a company in administration, against its wishes. Now, the administrator can say, actually, I want this to continue. I can fund it, I can do whatever. But there is a moratorium. That also applies in compulsory liquidation, i.e. you've gone to court and the company's gone in through a winding up petition. It does not apply in a creditor's voluntary liquidation. There is no, as far as I'm aware, there is no case law that makes clear whether or not adjudication is or is not subject to that moratorium. We take the view that it should be, and that if you have an adjudication in front of you as an adjudicator, when the company goes into administration, you should stop on the basis you no longer have jurisdiction, because the moratorium says that you can't continue claims unless, as I say, the administrator agrees to it on whatever terms that you can agree on your fees. But that's one where I'm seeing a lot of administrations at the minute, so that's one that's quite relevant that doesn't apply in liquidation, in creditors liquidation. So back to our kind of mandatory set-off type concept. We're looking for the final position under the contract because that's ultimately what we need to get to. The final position on a contract, under a contract, and in fact all contracts between the same two parties. For those of you who've looked at clause 8 of the JCT, and I use that, and I'll talk about clause 7 on the next page, just because the vast majority of the disputes we run are JCT, whether amended or not. This first one is one that my insolvency clients always struggle a bit with, that what was owed the day before insolvency is not what's owed the day after insolvency, which again, from our IP, from first principles, is wrong, because you're like, well, that's what I was owed. So that can't change because of insolvency, and this one is legitimate. Because what the contractual mechanisms say, and it's not just clause 8 of the JCT, the vast majority of well-drafted contracts will say, that's fine, whatever you were owed beforehand, we don't have to pay you now because that's a cash flow issue. What we're going to do is we're going to wait till the end of the contract when everything's resolved. We're going to take into account all counterclaims, and there'll be effectively a final net position. And then there's a balancing payment to be due. That's completely legitimate. It's not offending any, that particular formulation is not offending any insolvency principles, but it is something that IPs sometimes find hard. Like, well, hang on, the director said that was owed. Sure, and had you not gone into insolvency, that probably would have been what was owed. However, we're in a different world now where we do have to deal with those counterclaims, unless we can find any clever little legal outs. But leaving those aside, this is how your mechanism. So clause 8.7.4 usually applies whether or not it's terminated. It's not always. You have to look at 8.5.3 quite carefully. But effectively, what you do under 8.7.4 is you finish the works, you fix up the defects. This one's a subject of debate. We take the view that it's not the defect rectification period. We take the view that it's making good defects. JCT chooses not to use the defined term in 8.7.4. Our view is if they'd wanted to say defect rectification period, they would have said it. They talk about remedying making good defects. So our view is if it takes 6 months, and then the defects are finished, that's when you get your balancing statement. It takes 3 years, then that's when you get your balancing statement. But our view is that the defect rectification period goes out the window at that point. Some people disagree. I will make this, including a KC I know disagrees. But anyway, that's our view. So you've got 3 months to make your statement. And it is, what did it cost you to complete? So expenses, any loss or damage that you can actually prove. Come back to that in the final bullet point. Payments that were previously made, not the one that always gets thrown in. Oh, these were certified. Sure. How much did we actually get paid? Because that's always the one they sneak in was, oh, it was certified, sure. And had you made that last payment, company might not be here. And then what would have been paid to the contractor. I'm not going to talk about variations because the last time I gave a version of the speech, we ended up in a 20-minute debate about how to treat variations. So in the interest of it being a Wednesday night, I'm not going to go down that one today. But variations are obviously relevant. You're not just looking at the original contract sum that was in the contract. Obviously, the contract sum develops as the build progresses. So you can't just say, well, that for 8.7.4.3, oh, it's the original contract sum. Well, no, it's clearly not, because no contract ever goes that smoothly. There are always things change. Importance of evidence. So again, the last time I gave a version of this, Simon McKenny was in the room. I was quite pleased that I cited his article. It's a really useful article because the number of times that a large construction company will send you a spreadsheet and say, there's my evidence of the cost I've spent. Sure. As Mr. McKenny points out in his very handy article, a spreadsheet is evidence of literally nothing. It's just a bunch of numbers. We take with extreme cynicism, evidence is supporting documentation. But you would not believe the number of times that we're given a spreadsheet and told we should accept it at face value. Needless to say, we don't. But that is a useful little article if anyone's looking for some light reading. So 7.7.4 is your other JCT alternative to calculate what becomes due after a company's gone insolvent. And by the way, this is the subcontractor or subcontractor going insolvent. There is a mechanism, it's 8.8 or 8.9 in the employer. So there is a different provision if you're looking upwards, but I'm assuming on this basis we're always looking that we're the subcontractor and it's the main contractor So it's 7.7.4 in that scenario, which only applies if the contract's terminated, which leaves you in a slightly strange lacuna. If the contract's not terminated, where's your mechanism to work out what's due? But you just fall back to the scheme, because actually 7.7.4 is effectively the scheme. Or it's effectively like a common law, right? What's due less any legitimate counterclaims. So that one's more straightforward. 8.7.4 causes a few more complexities, but 7.7.4 is quite straightforward. Obviously, if the contract's non-compliant for any reason, you're back into the scheme. It's still incredibly common to see payment of retentions in the subcontract pegged to like a time under the main contract, which obviously breaches the Construction Act. I think, well, no, it's not. I know why it is. It's because the subbies don't complain. Half the time they don't read the contract. And if they do read the contract, they've got a pipeline of another 20 jobs for these guys. They're not going to go and cause a fuss. They might ask for the retentions early, but as long as they keep getting paid and as long as they keep getting jobs, they're not going to fight about a clause in the contract that happens to breach the Construction Act. They leave that for us once they go bust. So that's that's the main ones we deal with. NEC has obviously a different formulation, but in clause 90, but the JCT is clearer, and our preference, I have to say. I'm going to talk about enforcement next, having cantered through adjudication. And obviously, I'm very happy to answer any questions at the end, but with a mixture of online and in the room, I find it easier just to go through this and then do questions at the end. The main point to make on enforcement is that actually virtually every single case is obiter, because almost every single case was decided on grounds that were not actually relevant to enforcement on behalf of an insolvent company. Sometimes for natural justice reasons, sometimes for other reasons. So everything is obiter, which is a slightly odd place to be. Meadowside was the first time that we talked about ring fencing and insurance or security for costs, so that, and this is all about making sure the big construction company is not prejudiced by having to pay over money to the insolvent subby. We talked about ring fencing initially. That's sort of fallen away. So the ring fencing idea was effectively like paying into court. You pay it to the insolvency practitioner and they ring fence it, and it just sits there. They undertake not to touch it. And again, officer of the court, it's a perfectly acceptable undertaking. And it sits there pending, potentially, the debtor issuing full-blown Part 7 proceedings to have the adjudication decision overturned effectively.
Can we just make clear again, because everybody will, you operating this on a daily basis. So the presumption is you have pursued.
So we've won on
behalf of an adjudication.
We've won on behalf of an insolvent company.
Therefore, an award has been, a decision has been made that the contractor shall pay some to the insolvent contractor.
Exactly.
You're now seeking to have that adjudication decision enforced.
And by the way, the other point I should make is that this is actually quite rare. So we are covering, what are we covering? 5 or 6 years worth of case law here. If you think about the number of adjudications we run, and we win enough of them to keep doing this business. So most people do not fight. We don't have to enforce in the vast majority of cases. So most people pay or settle somewhere along the line between issuing the adjudication, getting decision, and issuing enforcement proceedings. A number of those also settle after enforcement proceedings are issued. So it's very rare we even get to court. And there were a couple of years where we hardly got to court at all. Now, Meadowside, to put in context, was after the Court of Appeal in Bresco. So you'd have the Court of Appeal saying, oh no, insolvent companies shouldn't adjudicate, that's a bad thing. So some of these, where all this ring fencing and security started, was effectively trying to find a way around that. You know, a first instance judge that thought adjudication was good, thought you should be able to enforce it, and was trying to think, well, how can I, within the confines of there being a lack of utility per the Court of Appeal, how can I find a way of saying, actually, we should be able to do this, this is a good thing. So we talked about ring fencing, which is, as I say, like paying into court. That's broadly fallen out of favor. I think the courts generally don't like payments being made into court. So unless, as an insolvent company, we had an award against another company that we thought or could prove was genuinely in financial trouble, I think that's the sort of scenario you revisit ring fencing or paying into court. If we're pursuing a very large construction company, you know, going after Michael J Lonsdale for 80 grand, like we were in Bresco, they were probably good for the money. So the ring fencing is broadly falling away. And then the arguments are, well, should you be able to enforce? And if you should enforce, does the company paying across money, or the company against whom you're getting judgment, do they get any security? Is it the same as being solvent, that if they don't like it, they pay and then they have to go and issue full-blown proceedings to overturn the decision? What protection should they have? And that's sort of where the balancing act is in the courts, and where we're going with the enforcement law. So we started with the security for cost concept. The problem with that is an enforcement hearing is summary judgment. It should be a 2-hour hearing. And you sit there and argue for 3 days about whether or not the security being offered is adequate. It's not really what summary judgment's designed for. It's not really what enforcement's all about. Enforcement in a solvent context, as we all know, should be, was there an issue with jurisdiction? No. Was there an issue with natural justice? No. Then we enforce. So there's a first principles question that says, well, actually, why should it be any different for an insolvent company? Now, I'll get to where we think the law should get to, hopefully will get to, is that actually you do enforce, but you get a short stay of 3 or 6 months, which allows the debtor, should they feel sufficiently strongly about it, haven't yet met one that does, to go and issue full-blown proceedings. And they take the risk, because actually, thinking about it, if we're sitting here as an insolvent company, what is the real difference between that and many other subcontractors who are technically still trading, but are absolutely balance sheet insolvent and potentially cash flow insolvent? You know, if you trade with one of those and, for example, you lose a smash and grab to them and pay them £500,000, are they going to be good for the £500,000? Probably not. So why should you make any difference the fact that there's a technical badge on this one that says it's technically an insolvent, technically in a process? We're not asking for smash and grabs, we're asking for final accounts. So there's a degree of finality. So anyway, we've moved away from ring fencing, and I say our view is we should have a stay. If they really think it's wrong, they can go and issue court proceedings and have it overturned. That's where we think the law should be, but I'm going to talk you through a little bit as to where we are and how we got there. So yeah, Meadowside was, as I say, in the context of a Court of Appeal decision that then got overturned by the Supreme Court. So although it gets cited, you almost have to take it with a pinch of salt, because it was a solution to a problem that no longer exists. And again, it's like all of these is obiter. Waxman and Balfour Beatty, again, obiter. It was an injunction case. But again, he was, agreed with the concept, you should adjudicate, you should be able to enforce. That was multiple adjudications. Waxman thought that you should put all the adjudications together and have them determined as one dispute. And was not very impressed that Balfour Beatty didn't agree to it. But that was an injunction case. Stiles and Wood is actually genuinely an enforcement case, and is the first one I'm going to talk about that isn't ours. And that was successful enforcement on behalf of a company in administration. It had with security insurance and security for costs, i.e. if GE then decided it wanted to go and issue overturning proceedings, there was some security in there for their costs, because in a normal scenario, they would be the claimant and they can't go for security for costs against a defendant. You only get to if you're a defendant going against claimant. So that was, I believe, the first successful enforcement on behalf of a company in admin. John Doyle and Erith, I'm also going to make clear, is not ours. We would not have run it that way. That's Court of Appeal. That's Lord Justice Coulson saying that he doesn't think you should be able to enforce. Again, it's obiter. It was decided on totally different grounds, and it's clear that part of the reasoning of Lord Justice Coulson was he did not like the way the first instance hearing was handled, and he felt that Justice Fraser, as he then was, had been put in a difficult position at first instance. So there were some other issues in that one. Liquidation case, all of the rationale of the Court of Appeal, both Lord Justice Coulson and Lord Justice Lewison, who supported him, turns on Insolvency Rule 1425. So we're back into that whole mandatory set off. Is there incompatibility again? As I say, we don't think there is, don't think there needs to be. Adjudication is just a tool to get you to a final account position.
Was that before Bresco?
No, Court of Appeal in John Doyle is post Bresco. But again, it's obiter because it didn't actually decide. And then I say they're all obiter in our view as well. You've got Court of Appeal obiter, but Lord Briggs and Bresco obiter in the Supreme Court was pretty supportive of enforcement. So what was I? My obiter is better than your obiter. So that's where we get to until we end up back in the Supreme Court again. So J. Vaughan St. Phillips is the next on the list. This one was ours. This is an interesting one. The judge was really fed up. This was one again where it should be a 2-hour enforcement hearing, and he sat there for 3 days, and St. Philip's Council threw in huge volume of submissions on natural justice, on the adequacy of the undertakings, and security. And I think we went for 2 days plus written submissions, which the judge did not think should be how a summary judgment application should be run. So he ends up at the end of 71 paragraphs, concluding that he didn't enforce on the grounds of natural justice, but had he would have just enforced with a stay for 6 months, full stop, end of story. He got into extensive, and I've had people say to me, but there's huge discussion of security. There's huge discussion of huge volume of issues, because all of these were canvassed before the court, and the judge felt he had to address them in his judgment because he'd had such extensive submissions, but actually that's the conclusion he reached. And then following JBO, giant trading is unreported, but we got, again, that's ours. We got enforcement just with a 3-month stay, no meta-side arrangements, no security, just 3-month stay to allow the other side to overturn, which they did not. I have an article, if anybody wants a slightly more detailed look, that I wrote for Practical Law about adjudication enforcement, which goes as far as that does. There will be more law. There inevitably will be more law, but that's where we're at presently. And that's my little canter through construction insolvency, enforcement, adjudication. Questions?
So the two chaps on the computers are now looking to see if there's any questions in the chat room. Right.
Dazzled.
In which case I'll take questions in the room.
Oh no, hang on.
So. Jennifer, I'm aware that we had a conversation earlier about the fact that this is being recorded. It's obviously it's online.
Mm-hmm.
Could you, and you said that if, as it's being recorded, you might have to be a little bit candid about one or two things.
Yes.
And I completely accept that. Would you be prepared to talk about the model and the approach that Pythagoras takes, and how you assess whether or not these are worth running?
Yeah. No, very happy to talk
Well,
about
I think
that.
it'd be useful because it's something that happens and is increasingly happening.
Mm.
We're seeing even more. I mean, what with ISG just having gone, Beck having gone, there's some big players around, and very recently.
No, absolutely. So we are, we're a bit unusual in this. Not unusual generally. We're a bit unusual in this space. So we act as agent for the insolvency practitioner. So company goes bust. You have appointees go in, they have these powers and duties. Construction is not something you do every day as an insolvency practitioner, even if you get lots of them. And pursuing construction debts, where people are notoriously reluctant to pay, is certainly not in their sweet spot. So it's something they will always appoint an agent to pursue. We're unusual because before we came along, mostly people went to firms of quantity surveyors. Now, obviously, there's part of that they can do, but a lot of this is legal and contractual and actually insolvency law related, because all of these mechanisms are taking us into an insolvency law world, not just a pure construction law world. So as a firm, we are lawyers and we have in-house engineer and QS, because we know people that we need to have people who understand how to build a building, how to assess completion costs, because of all these spreadsheets we receive with random numbers in them. And we make them really cynical. Our senior engineer started, and he'd go in with a view of, oh, I believe this. And now he's like, right, they're lying to me. Just need to prove it. So we've totally corrupted him. But we will get given a book of debts. And obviously they have a face value that was in the company books and records at the time it went bust. Some of those will be good. Some of those will be dreadful. Some of them should have been written off years ago. And we will generally take on that entire book of debts. So before we even get to an adjudication, we've got a big investigative piece where we work through and build the claims, which involves using some of the insolvency practitioner's powers under Section 236 of the Insolvency Act to get information, using the mechanisms in the contract, and then we assess the ones that we think have legs, have merit, and are worth pursuing further, and that have not settled before that. And then we end up in adjudication.
And without going into percentages, without going into the confidential stuff, then it's obviously a case that the model is based on a recovery above a certain point.
We keep a percentage of what we recover. And it's, if you think about it, we're taking on the whole book, and we don't believe in just going after the low-hanging fruit. We believe in tackling everything. So if it's a debtor book, Might be £1,000 claim, might be £1 million claim. We will pursue all of those claims. A, because we think it's the right thing to do, and B, if you think about it, the guy that owes £1,000 this week, if you let him off and don't pursue him properly, next week he owes £1 million, he's going to think you can get away with it. And obviously we see a lot of the same companies all the time. If most of our work is subbies against contractors, so you're seeing all of the same names constantly. So we do pursue everything vigorously, and then some of them will spend a lot of time and there's nothing there. Either we'll decide the claim doesn't have merit before we get to adjudication, or we're going to do an adjudication and lose and decide it's not worth pursuing further. So we punt a lot of time and quite a lot of money at it, and then we make our recoveries on the ones that are worth taking, we win.
James?
I haven't got a specific question yet, but what I'm curious about is
Remember, I'll have to repeat it, so try and...
when you're acting for subbies or who what I'm interested in is the role of main contractors, and particularly where they've got really long payment terms. Is that something you see an awful lot of? And what sort of role does that play in A, what you do, and B, the subbies' journey to where they've ended up generally?
So we tend,
Hang on,
oh, sorry,
for the benefit of the people online. So the question was to do mainly as contractor to subcontractor, and the subcontract contains a very long payment period. And what are the aspects of that that would affect your recovery? Is that fair? Right.
Yeah.
Off you go.
So once that gets to us, not really. So that's probably what that may have been a contributing factor to the company going under in the first place. Slow payment, either extended payment terms and or slow payment generally. Generally, it's more under certifying. You can, depends which way you're looking at it. As a subby, you'd say it's being under certified. As a main contractor, you say they've over applied. So usually it's somewhere in the middle. But the payment terms are usually just yet another thing that helps drive the company under. But once we get involved, and once the company's gone insolvent, whether or not there was an extended payment time isn't really relevant. It was what's accrued beforehand, and then what do we have to set off afterwards. But that can be a contributing factor.
As a humble
Cool.
expert, I don't get involved with these major jobs. Hopefully the builder will do his job and he goes away, and it probably wouldn't be worth troubling a firm like yours. But anyway, no, it's just this is a more general point of law, which interests me as an occasional expert witness. And I made a note, so I think I'm right. Insolvency practitioner is an officer of the court. One, it'd be nice to have a definition of what is an officer of the court. I've heard that term in legal terms. Held to a higher standard, then my question would be, what is the higher standard and what is the lower standard that applies to other people who are not from? It's very logical.
So Paul, can I, because we're doing this for the benefit of people online. So the question is Jennifer made reference to insolvency practitioners being officers of the court and being held to a higher standard. So one of the members here has asked, what does that mean?
And I would have to, at that point, defer to one of my technical insolvency colleagues who could be able to cite you where exactly it comes from. So if you were to go into an insolvency court, so leave aside the construction court here. When I say higher standard, there is a standard of behavior that is expected from an insolvency practitioner. They're not meant to use dubious angles. They're not meant to take minor points. They're meant to adhere genuinely to a higher standard. So the court will expect a certain standard of behavior from them that they might not expect from, say, another professional. So lawyers are officers of the court, IPs are officers of the court, but they might not expect, it's an obvious one, to say a banker, and I don't really mean it that way, but a banker or a non-insolvency accountant might not be considered to be held to that standard. Taking a normal commercial advantage in a contract, if it's slightly questionable, is not something that an insolvency court would expect an IP to do.
And you're referring to a banker acting qua expert witness, not just
just generally, generally in practice and professional life.
I mean, CPR 35, what interests me really, is there any reference to officer, an expert witness in a court is not an officer of the court?
No. So again, it's just trying to get to the definition of an officer of the court. So an officer of the court is somebody who's going to owe a conduct to the court. And you're quite right. The question was regarding now going to expert witness. Expert witnesses will owe duties, and they'll owe duties under the court under CPR Part 35. Equally, there will be codes of conduct expected of officers of the court, which would be solicitors and barristers who would have duties to not mislead the court and other things that we need not get into today. But I think in
No,
simple
that's right.
terms,
Yeah, so
that would be the
it's not-
standards expected of practice in front of the court.
Yes, and so we're not talking CPR. This is just
No, I
deriving.
appreciate it.
from-
Yeah.
It's just interesting.
Jennifer, again, you've spoken about the utility. Well, now post Bresco, do you often find that just the very threat of adjudication with a reasoned basis for wanting to pursue the debt is reaping rewards without the need to actually go through adjudication? Or do you really have to pursue it before they'll think you're being serious?
Sometimes, probably slightly. People were probably more inclined to settle than they were pre-Bresco. I think we've been around for long enough now that people know us and they know that we will adjudicate. So it's not a hollow threat. You know, other participants in the market might threaten adjudication, but if they haven't got the financial wherewithal or the ability to run the adjudication, no one's going to believe them. Whereas I think people know that we will. So I think that helps. I think people's willingness to settle is also just partly dependent on market conditions. You know, people are keener to kick the can down the road at the minute and not deal with the problem and not have to pay unless they can get out cheaply. And as I say, that's just market forces. That's just, it's not a great time to be a construction company at the minute.
No.
Presumably.
Yeah.
So,
And then I'll come back to you. So
once you commence adjudication, how often do you withdraw from those?
Jennifer,
I'm
so the
sorry.
question is,
I keep forgetting.
once an adjudication has been commenced by Pythagoras, how often do they then drop it and withdraw?
So there'll be the occasional one where there's maybe been a problem with service. So it's a technical, we'll withdraw and then reissue straight away because somebody makes an argument on jurisdiction that we think has enough legs to withdraw and reissue. Other times we might withdraw after we get the reply. So bear in mind that
Response.
so I always get that wrong. I always say reply when I mean response. I don't, you can tell I draft bits of them. I don't actually submit them. It's, bear in mind that when we get to issuing adjudication, we've been through a process. So we've requested information. We've tried to engage the party on the other side repeatedly. We may have asked repeatedly for information. And then we get to an adjudication. And at that point, you've got to work on the assumption that that information does not exist. They might claim it does, but if they're refusing repeatedly to give it to you, you sort of have to work on the assumption that it doesn't exist and issue the adjudication. So there are certainly times when a response will come in and we look at it and go, well, that's fine, but we've been asking for this for 6 months. Had you given it? Actually, you wouldn't have just spent 20 grand defending this and having your response drafted. So it's a bit of a waste of money and a bit of waste of everyone's time. As a percentage, 5% maybe. So not a huge number, but there are certainly ones that come up that, as I say, they produce information. I'm like, well, no, we don't think there's a claim. And say, had it been produced previously, we'd have all avoided this process.
Question here.
Similar thing I was going to say, you feel a case has got no legs, and when you've looked into it, you've probably just turned it away with you. Because commercially, it's not worth it.
Well, it's not worth it. We're spending them.
sorry.
Oh, sorry, every time.
So the question is, if the book's been looked at by Pythagoras and they've decided that this one's dead in the water, you know, they're just going to drop it. If you know, how often does that happen? Sort of,
Yeah, so say, I don't know. Yeah, well, it is. If you think about any construction company, you know, there's a book of debts, there's a book of retentions. Some will be worth it, some will be not. When you've got that intervening insolvency, you'll have a bunch of contracts where the contract was partway through. Chances are it's going to cost more to get those works completed than they would have been with the original contractor. So you've probably got a big counterclaim. So those ones are always going to be harder to win. So yeah, there will be a lot that will get rejected along the way. There'll be some that will settle along the way. And then there'll be some that are left that we think are good claims. But we haven't got any proper engagement from the other side, and they're the ones we run to adjudication.
percentages of those. Just saying this again for the mic.
Do we maybe run somewhere between 10 and 20% to adjudication, maybe? We have a very large volume of claims on the book at any one time, and at all stages. You know, companies that have just gone bust to ones that are older in the tooth, and we're just cleaning up the end of the debtor book at the end of all the defects periods. So,
And it's a simple QS. You explain what's the difference between the insolvency practitioner
The question is, as a simple QS, could I just say, I mean, I'm one of those, so that's tautologist. You didn't need to say both anyway, but as a simple QS, what's the difference between an insolvency practitioner and a liquidator?
Okay, so the insolvency practitioner covers all accountants who are licensed to take insolvency appointments. You have administrators when a company's in administration, and you have liquidators when a company is in liquidation. You also have supervisors of voluntary arrangements, but don't worry about those. The main ones are administrators and liquidators for our purposes. So they are all insolvency practitioners. Yeah. So an IP is just an accountant who is licensed to take insolvency appointments and insured. And the two main types of IP you will come across are administrators and liquidators. And they're individual appointments, by the way. Everyone always says, oh, PwC has been appointed. No, they haven't. Two individuals at PwC will have been appointed as administrators or liquidators. It's a personal appointment. So yes, they're part of a firm and have insurance and everything else, but actually it's a personal appointment.
And something we've found chasing debts, funnily enough, as an adjudicator, do you find that there is a difference in enforcement between the different countries? So in Northern Ireland, as opposed to Scotland, as opposed to England and Wales?
So we don't do anything in Northern Ireland. The only ones I have that are Northern Irish are actually all the contracts are English and subject to English law. And if we're issuing an enforcement, even if the debtor is Northern Irish, as long as the contract was subject to English law, we'll enforce here. Scotland, the law on enforcement of the award is slightly different. But generally people pay in Scotland. And I'm Scottish, right? So, you know.
I'm just going to emphasize, just in case that wasn't on the mic, there was an awful lot of laughing in the room.
Our experience is.
Oh, yeah. Edward first.
Is there a specific form for that or format or is something under the Insolvent?
So the question is, a fellow adjudicator who I recognize in the room is interested to know the specific form of words that might be used as an undertaking to be prepared to guarantee the payment to the adjudicator for continuing with the adjudication. Is there a specific form of words?
So to be clear, and this is an undertaking that comes from Pythagoras. So this is because we are the ones funding the adjudication. So the administrators or liquidators are not taking the risk on costs. We take the risk on costs. That's part of the deal. That's part of what drives of how we work. We guarantee, it's about a line, we guarantee the fees of the referring party to the extent that the referring party is liable to pay them. It's what you will get from us in our adjudications. It's nothing to do with the Insolvency Act. It's just a form of wording that we use to give the adjudicators comfort.
And interestingly, both we were both at an arbitrators and adjudicators conference this weekend, and somebody was talking about being paid and saying just be careful that the practitioner does not give you an undertaking subject to the recovery of the money. It's got to be an absolute guarantee of the paying your fees.
And that's why it's easier for us to do it, because for an administrator or a liquidator to give an undertaking to pay is difficult. They can't do it unless they have
You're acting as agent, right?
We're acting as an agent, but we're the ones funding it. So it's our money. It's not the estate's money.
Yeah, there's no fiduciary requirements. You are just taking risk.
And it's, but it's a commercial risk. Whereas for the IP, there's a whole host of regulatory related risks in giving that sort of guarantee. Not very often. Oh, sorry.
Right. When they run adjudications, how often do they discover that the responding party fails to involve themselves and must have to proceed ex parte? Yeah.
Very rarely. I've got a couple that we've had recently, but that's kind of quite a specific set of facts. But I would say maybe 1 or 2% of the time, if that, people don't participate. Virtually always. There was a period of time, kind of pre-Bresco or pre-Supreme Court, when people thought we couldn't adjudicate or couldn't enforce. So we were just wrapping up decisions, just thinking that's fine, we'll just rack them all up and then we'll enforce once we sort out Bresco. But people, I think, now know that we can adjudicate, that as much as there's talk that you can't enforce, people know that we do and that we're still doing this. So 99% of the time, people do participate. And a couple of times, other than this one specific set of facts I'm thinking of, I think the last one where somebody didn't participate was because they were about to go bust. So
awful lot of that. Yeah.
Yeah, I would probably agree with those percentages. I've had only probably a couple of occasions where a responding party hasn't issued a response. But the point I think is that the referring party, you need to look at their case and look at the evidence, and you can't just take it on face value and issue what they're claiming for. You need to test it.
And there's not so much, just a statement in the room about you need to see the whites of the responding party's eyes to actually know if there's something worth. So a practitioner was saying that in his experience, the vast majority of responding parties will engage at least to that stage. Is that the point, Roger?
Yeah. I think
Yeah,
so,
yeah.
yes.
Question here.
Yes, my friend, where you see it through to enforcement, when it comes to the security arrangements, do you see a marked difference between the administration situation and the liquidation situation?
So we're getting technical here about going to enforcement, and is there a marked difference between, I guess, an IR is going to be 25 or 24 between administration and liquidation?
So this is an interesting one. So we're trying to move away from the security part because it just, as I say, it complicates enforcement at summary judgment, which it shouldn't. There is a difference between 1425 and 1424. Rule 1424 is mandatory set-off, but Rule 1425 applies mandatory set-off as at the date of liquidation. So once a company's in liquidation, it applies immediately. What most people don't, a lot of people don't necessarily appreciate is that it's different in administration. So Rule 1424 is broadly the same formulation in terms of talking about how the set-off applies, but it does not apply if you've not issued to any class of creditor. So it doesn't apply from the start of administration. And you could go through a whole administration and it not apply. At the minute, the first instance judges that have looked at enforcement are not, this case law is quite complex and quite convoluted. And these are construction judges looking at what's quite a technical insolvency point. And bear in mind, these points are usually argued by construction counsel rather than insolvency counsel. So that point's not always explored. My personal view is that you can distinguish John Doyle's obituary comments because they're all about 1425. So if you stay in administration and don't distribute, you take out so much of the commentary in John Doyle because it's all about Rule 1425. Well, if you're not even in the equivalent provision, that just disappears. That's my view. Others disagree, I know. It is a different process, but yes, it's until we got to really Supreme Court in Bresco was the first time we really had a judge who had substantial insolvency experience. And we had an insolvency case arguing that. He argued it at Court of Appeal as well, and then offered very quickly to come back to the Supreme Court because he saw which way it was going. So yeah, you just don't tend to get into those nuances, and I don't know that we will again until, you know, if we end up back in the Supreme Court again.
Any other questions on anything online, Eddie? Has anything come in? Yeah. Wait for a second. Yes. Yeah. All right, we'll take another question in the room whilst Eddie's looking up online.
You can't chase it, but you can't incur costs for the IP and whatever else. So you've got to do the time as a dead duck.
So the question is about chasing a dead duck, but of course, it's not the IP, it's going to be the agent. So it'll be a decision. Sorry, you answer the question.
Yeah, so it is. It's
Yeah.
it's
Can you just explain that?
yeah. So it's not such that I mean, if there was just one claim in the estate, and that was what the IP was keeping the estate open for, there was nothing else to do. You were just waiting for HMRC tax clearance and close down. That's one thing. But if there's a whole debtor book, there will be some claims that are clearly not claims, but there are also some that are very much on a grey scale of, you know, more to less speculative. And oftentimes, if people don't want to give you information, it's quite hard to know clearly whether or not it is a dead duck. So actually, it's in the IP's interest to maximize the estate. So if there's a poor claim that we can put some pressure on and get a settlement, even if the prospects weren't brilliant, then actually it's in the best interest of the creditors to do that. The IP is not incurring costs so much because it's only the cost of keeping the estate open. And often there are lots of other things to be done. Might be claims against directors to be pursued. I understand that getting tax clearance from HMRC takes forever. So there's a lot of other things that need to be done in the estate. It's not just about pursuing the debts. So I wouldn't say that there's a cost being incurred so much. Equally, it's in our interest and it's in the IP's interest to carry out this whole process as expeditiously as possible. If there is a cost to leaving an estate open for years, if there are monies we think are worth pursuing, then it's worth keeping it. If there's not, and we can wrap things up quickly, we get paid, the estate gets paid, creditors get dividends. It's in everyone's interest to do it quickly.
And I'm guessing, obviously, there will be cases where you will be making payments to existing staff because, of course, if you've got, despite having in-house staff, there can be no replacement for the guy that was running the job and knows where the money's buried. So presumably there's payments being made to in-house QSs or some of the people to keep.
I try not to. Well, I think it depends who you're talking about. If you're talking about a former QS who's off, got another job, then there's definitely, there's a payment to be made for time. Now, whether that's a contingent payment, because actually what we always would, we get paid contingently. We like to have everyone else being similarly invested. And if they're going to help, we want them to be properly incentivized to help and to succeed. With directors, they have a statutory duty to assist.
Yeah.
So actually, we remind them of that. Sometimes the IP might lean on them a little bit and remind them of those statutory duties. And they do have. So with directors, it's a little bit easier. The directors have often also either owe money into the estate or maybe have a personal guarantee to the invoice discounter that introduced us to the job. And therefore, it is generally in their interest to be helpful. That doesn't mean they always are, but it is often in their interest to do so.
Anything else, ladies and gentlemen? Yes. Yep.
Do you find from experience that when a company goes into liquidation, sometimes it can try to control the liquidator? We've seen that before. Yeah.
So QS asking a question about companies going into liquidation and seemingly attempting to control the liquidator.
I guess there's two ways that could happen. So when you have a creditor's voluntary liquidation, there's not really any voluntary. This is the directors see the writing on the wall and either there's a winding up petition being heard or they file it themselves. So the voluntary is not really voluntary. Creditors voluntary, the directors choose the IP, but they can get replaced by creditors. So if the creditors are not happy because they are,
That's exactly what happened here.
yeah, look, it absolutely does, and they're definitely, depending on the level of trust between the directors and the creditors, which may be quite severely dented by that stage, you will often get creditors. You will also, for two reasons. One is the creditors might not trust the director. The other reason is a legitimate one. The director might have gone around the corner to his accountant and said, I need an insolvency practitioner. And the accountant recommended someone he knew. That person might not be the best placed with the best experience to handle a job, particularly if it's a large company. So there can be quite legitimate of the large creditors going, actually, you're not in control anymore, Mr. Director. You no longer have an interest other than to be helpful. Actually, as creditors, we control this process. And as the major creditor, actually, you know what? We want someone that we know that we think will do a good job and might scrutinize more closely what the director did in the run-up to the insolvency. And that's a lot of them.
Exactly what happens to us.
And look, as I say, IPs have duties and powers, and they absolutely are held to a higher standard. Are there some that are better than others? Absolutely. They should be held to a higher standard. And look, in every profession, there are people that give it a bad name, right? And as I say, sometimes there is no actual criticism. Sometimes it's just the creditor saying, you know what? I just don't like the fact that the director chose you.
Yeah.
So I'm just going to put someone else in because I'm far more comfortable in that scenario.
Ladies and gentlemen, I think we've got to the end of these. I feel a question, or at least some discussion maybe coming on at the bar about some live issues down here in the front row. But anyway, can I just come back to thank Jennifer, because this is a technical subject. It's, as we have seen, it's an interaction between insolvency law, which we could talk about. No, she could talk about for hours, and many of us in the room who could talk about adjudication for hours. But it's great to have a speaker who is able to sort of meld those two together and give us first-hand knowledge of so many of the cases upon which this developing law is based. So I'd like you, please, to show your appreciation in a normal fashion. Thank you.